Hey y'all, welcome back. My name is Paige Hulse and I am the attorney behind Paige Hulse Law. And today I'm going to be talking about a topic that has been weighing pretty heavily on my mind for a while now, and that I have intentionally waited to talk about because I felt like I needed to find the exact right things to say about it. That being said, today I'm going to be tackling the issue of copying in the creative industry. I have a lot of mixed feelings about this topic, and typically, if you've been watching any of the videos I've been putting out, I spend today talking to or interviewing another business owner in the creative industry that I look up to and that I want to glean some insight from. But today's topic was really important to me, so I decided to dedicate the entire talk to tackling this topic. And like I said, I have a lot of mixed feelings about it. And this is actually going to be the most unscripted video that you see from me, probably. Because on one hand, I sometimes think that I think that this is kind of a hot button issue in our community right now. And if I'm being totally honest, I think sometimes it is an overused term. I think it's something that we kind of hide behind just because it kind of inflates our own sense of self every now and then to say somebody's copying us. But on the other the much more real side of things, as a lawyer, this is something that I see and that I have to help my clients protect themselves from all the time. And it happens so much more often than I would ever like to see have happen. And it's not something that there's a very clear-cut answer for. So anyways, today you're going to hear just a lawyer's musings on the topic of copying. And I hope that what you can get from this topic are some actual practical insights into this issue, maybe some ways to protect yourselves, and some ways to just some things to keep in mind as you're building your business, and best practices moving forward to protect yourself from copycats. Okay, and I'm going to start with a quote. This is my favorite quote and I think it sums up everything that I want to say about the issue of copying. It's by C.S. Lewis, and if you follow me on Instagram, you've probably seen it pop up a time or two, but I'll read it to you here. Even in literature and art, no man who bothers about originality will ever be original. Whereas if you simply try to tell the truth without caring twopence how often it has been told before, you will, 9 times out of 10, become original without ever having noticed it. So I think the issue that I want to get to, what I want to get to at the heart of this issue today is we have to protect ourselves not only from being copied, but from accidentally copying other people. And the only way that we can do this is by kind of like boiling down and getting to our truths of our own businesses. And I know that for me personally, this means that I do not, I'm in a very small community. There's not many other, creative attorneys, but just entirely honestly, I don't follow anybody on any platform. I intentionally go out of my way to avoid everything that I can that would possibly cross paths with another person in my industry. That means that I intentionally will try to find like the podcasts that people aren't listening to. I try to find different entrepreneurs that people aren't really following, and I try to kind of pick things from different industries and incorporate it into my own. I know that I'm in a different circumstance because in my industry, I'm one of the few. I am the person when I go to other law, like mixers or, whatever you want to call them, different bar association events, I should wear a camera because nobody has any idea what I'm talking about when I say I'm an attorney for creative entrepreneurs. So again, I'm in I have a different perspective than a lot of people do. That being said, I know that if, for example, you're a wedding photographer watching this video, you have the exact opposite problem as me. And not only are you one of many, which doesn't lessen your value whatsoever, but one of many photographing the same event, which is, a bride and a groom in a white dress and a tux at a beautiful, on a beautiful day with a beautiful bridal party, etc., etc. It can be really, really hard to stand apart. And I want to just preface with saying that I understand that, I recognize that, and I don't want anything I say today to diminish that scenario whatsoever. So that being said, let's just dive right into the issue of copying. This is an issue that I came across personally about a year ago. I had a calligraphy company. Some people know that, some people don't. And it's happened a couple times, but the first time I remember very vividly when it happened. I saw one of my prints used on somebody else's Instagram account, which I know I've touched on quite a few times. But, and that was, incendiary enough. But it really lit a fire under me when I saw that person selling the print that looked just very, very eerily reminiscent of my own in their Etsy shop. And once that happened, I realized, if I'm just a small-time calligrapher with these types of issues, this is obviously an issue that is very pervasive in our industry. And I started kind of paying more and more attention to it. And I'm sure if you are involved in any sort of creative community or listen to podcasts or anything, if you have any sort of touch on our creative community, you've heard this issue talked about. It's something that plagues all of us. I don't care what industry you are in. I don't care if you're a copywriter. I don't care if you're a calligrapher. I don't care if you're a photographer or even an attorney. It happens to all of us. And it's something that we need to just kind of face head on. So first things first, what do you do when you find that you've been copied? The first thing that you do is document it. I want you to screenshot whatever you're looking at immediately. If you can, I want you to be able to have some sort of timestamp on the document and just start building a record. Every single thing that you say, every single thing that you find, everything that could possibly pertain to your case, because let's face it, that's what you have at that point is a case. I want it to be documented. So first things first, screenshot the image or whatever it is that you found that resembles your work too closely. The next thing I want you to do, and I've written a blog post about this, and I'll link it to this video, but the first thing I want you to do is reach out to that person. Again, I want it to be in writing, and even if it is a phone call, I want you to follow it up in writing. I want you to very politely just say, hey, I saw that you posted, this photo. It looks very similar to my own. If it is based off of my own, I would ask that you give me credit, something along those lines. Keep it very friendly. Don't inflame the situation from the get-go. That's the key here. You don't inflame the situation. 9 times out of 10, the person's going to respond and they're going to say, oh my goodness, I'm so sorry. I didn't mean to copy you. I'll fix it right away. And that's something I do want to touch on for a moment. So fun fact, not many people know this about me. I was actually a history major in college just because I'm entirely nerdy. And quite a few different Greek philosophers, I'm like really showing my nerd here. Quite a few different Greek philosophers have philosophies on the topic that there's no such thing as original thought. Everything that we do is based upon somebody else's previous thought that has influenced us in some way. There's different books that have been written about this topic recently. But, that being said, I do think that not everybody out there is evil, and I think that sometimes we do accidentally allow ourselves to be influenced by different mediums and different things we hear and that we read. I'm an auditory hearer. I'm an auditory learner, and so every single thing that I hear, I don't forget it. It's seared into my memory. Some people have a photographic memory. So when you have something like that, it is very hard to not be influenced by what you hear, which again is why I want you to take the offense and go out of your way to protect yourself from accidentally copying somebody else. But that all goes back to my original point of not everyone who copies you is doing it on purpose. And you're a business owner. I know it's personal, but at the end of the day, you're a business owner, and I want you to subtract all emotion from the situation. And so I want you to reach out to that person and give them the benefit of the doubt that they are not copying you on purpose. Step number 2, if that doesn't work, is send them a more, put some oomph behind your letter. Be a little bit more direct with your letter. Your second letter should say something along the lines of, I contacted you on date regarding this photo. Send the screenshot of your screenshot that you grabbed earlier. Say this image, this caption, this whatever it is, too clearly reflects my own. I would ask that you remove it immediately, or else I will take, necessary action. If that doesn't work, you have your third option is to send a cease and desist letter. This is something, again, I've touched on in other videos that I'll link to this video, and I don't want to get too much in the weeds here today. I've also hit on it quite a few times in my blog posts. But this is something that you can send on your own, or you can contact an attorney at this point and have them send something on your behalf. Anytime something is sent on an attorney letterhead, even if it has a verbatim exact wording of something else, is going to it'll carry a little bit more weight, and you would be shocked at the difference in response that you would get from sending the exact same thing on attorney letterhead. So that's your third option. So those are issues, and this is like totally unscripted. This is just a conversation that I have with my clients when they come to me with any sort of copying issue or when they want to prevent copying. Okay, so second thing to keep in mind, those are responses that you can take like after the copying has happened, but of course the question you should be asking is, how do we prevent the copying from happening in the first place? And that comes down that'll come down to 3 areas, and I'll touch on all 3. One is copyrights, one is trademarks, one is protecting yourself online, which usually is just having the right terms and conditions in place. Okay, so first things first, let's tackle copyrights. Copyrights, and I have it written down here so I can get it exactly right for you. Copyright is a bundle of exclusive rights in an original work of expression given to the author of that work. This is something that is only going to be available to creative works such as authorships, photographs, just any sort of creative work. Even architecture in some situations can fall under copyright protection. So when it comes to copyrights, the minute that you create that copyrightable work, I don't know if that's a word, but we're going to go with it, you have what are called common law copyright rights to that work of authorship. What this means is that you own the work. On a practical level, what this means is that you won't necessarily have the legal capacity to actually enjoin or stop somebody from infringing upon your work if you have not registered the work. So that leads us to, how can you protect your copyrighted works? Number one way, like I already said, is register your work. This is going to give you the right to stop somebody in a court of law from infringing upon your work. Of course, there are many other facets that are involved in that. You're going to have to prove your ownership. But again, registering the work is going to be automatic proof of ownership, and the first layer of protecting your work, proving your case in court. And in some scenarios, when you are able to do so, you will automatically get certain judgments rendered against the opposing party, different numbers, different monetary figures that are set by statute that you can recover for each copyright violation instance. So second, what are trademarks? Just in the colloquial sense, I don't want to get too in the weeds with all of this today. Trademarks are the distinguishing factor or element of your brand that separates you or distinguishes you from a separate brand. This is a slogan, this is a logo, this is your brand name. Those are all trademarks. Nike is a great example. Anytime you see the word Nike, you think of that brand name. Anytime you see that swoosh symbol, you think of Nike. Anytime you hear the words "just do it," I would be willing to bet that you think of the brand Nike. Again, just like copyrights, there's some different factors involved with the case law. But generally speaking, just like copyrights, unless you register your trademark, you will not have the right to stop a person in the court of law from infringing upon your trademark. It's can be a race to the courthouse type scenario. And again, this is me speaking in vast generalities, but it can sometimes be a race to the courthouse to see who can register the trademark first. So again, if you haven't taken the steps to register your trademark, you're kind of just a sitting duck. And if you have a product that you want to protect, or a name, or any facet of your business that could fall under the guise of, or not under the guise, but could fall under the purview of trademark law, that's something that you want to consider trademarking at the outset. Because if you see somebody copying your brand, copying the name of your product or, slogan or anything from the outset, you want to have the ability to stop it in a court of law. On a practical level, what I'm talking about is if you don't have those works registered on a copyright or trademark level, you can send them that cease and desist letter, and you can throw in all the bark that you want, but it's not going to have any bite whatsoever if they have any sort of, if they're legally savvy in any way, because if you don't have it registered, they're going to know that you don't have the ability to actually stop them from using it. And what that means, again, on a practical level, is a lot of times all you're doing is putting that person on notice that you are going to fight for that name. We'll pretend like I'm just talking about a brand name here. That's just going to put the person on notice that you want to fight for the name. And they could very well beat you to the punch and register the trademark first. And you can enter into a lengthy legal battle to fight that with the USPTO, but that's going to cost a lot of money. And at the end of the day, as much as I want you to protect yourself legally, I will any day of the week, I'm going to tell you to do what's best for your business from a business perspective. And sometimes entering into those legal battles is not that thing, because it can get costly and time consuming, and it can just cause a lot of angst, and it can detract from you actually, putting any sort of momentum into your business. So going back to the idea, like I talked about with my Greek and Roman philosophers, there's the concept, and the American courts follow these rules as well, that there's truly no such thing as original thought. We are all on some level influenced by one another, and we all build off of one another, and very rarely do we actually create something that is truly an original thought. So that being said, courts have taken that into account, and they will allow different parties to be heavily influenced by another party, for lack of a better word, but they will draw a line between that and expressly stealing from another party. So again, this goes back to my original point of any time that you see what you think might be somebody copying you, you need to document it. If you are wondering if you've documented it enough, that means that you have not. You need to document it in every way that you possibly can. Anytime that you communicate with that person or you see the infringing work online, I want you to have a screenshot or a saved image of their use with that timestamp in place. Because the more of those types of images that you have in your file, the more you are able to sway the judge from thinking that it is influence into thinking that it is actually, stealing. It crosses that line. You need to do everything that you can to actually show the judge where that line is. Okay, so going back again to how you can protect yourself from being copied before it happens. Again, this is honestly the hardest part of my job as an attorney, because my job is to, I've said it before, my job is to look into a room and see the ghosts that nobody else sees in the room. My job is to plan for the unexpected in every instance. And copying is something that you honestly nowadays you can always plan that will happen, but you don't know where it's going to come from or exactly how it's going to happen. So the first thing that I do is I always have my clients have a very strong terms and conditions in place on their website, because most of what we do is web-based. And I'll try not to get too nerdy on you with this, but if you have that terms and conditions in place with the right wording in place, you can have provisions in there that say that you are not allowed to take any of this information from my website and use it without my permission. You're not allowed to take photographs from my website, all sorts of things like that. And what this does from a legal perspective is, if you find that somebody has taken, I don't know, let's say they've like copied a blog post or something dumb like that. If you find that somebody has taken that information and used it on their own site, then you have entered into the realm of contract law, which is much more black and white than what I would argue intellectual property law is. And instead of saying that somebody has infringed on your copyrighted work, because technically anytime you write a blog post, that's a copyrighted work of authorship. You've authored it. It's in a fixed form. It's in a fixed medium, your website. It's creative. It's your own thoughts. That falls under contract or copyright law. But if you have those terms and conditions in place on your website saying that they can't take that blog post, then the person is, then you can easily, levy a breach of contract claim against the person. And that is a claim that I would argue all day in court over an intellectual property claim. It's going to be much easier to prove, because anytime somebody is using your website, if you have terms and conditions in place, and if there's factors involved, but if it's something that a document they're able to access easily, that they can read, that's there, by using your website, they are inherently agreeing to those terms and conditions. So if you have a term in there that says, hey, you're not allowed to take any of my information from my website and publish it on your own site, and they do that, and you find that blog post on their website, then you can take them to court and say, hey, this is a breach of contract case. They breached, you see that squirrel? You can take them to court and you can say, they have breached this contract. They used my website even though these terms and conditions were in place, and they did exactly what I told them not to do and what they agreed not to do when they started using my website with these terms in place. So that's kind of, it seems very simple on the outset, but that's the easiest way to protect yourself from any sort of copying online. That also comes into play when you have any online courses or any sort of like webinars, or like, I'm not real tech savvy if we're being completely honest. So I'm not exactly familiar on all of the different platforms you can host webinars on. But I've seen a lot, or not webinars, but different online courses. But there are quite a few where you have an ability to make it password protected. So first, that kind of eliminates who can actually access the course. And this is something, I'll be honest, I sell in my template shop, and it is the best seller in my template shop because it's something that anybody with an online course needs. But you can have online terms and conditions in place where, by accessing the information in your webinar, in your online course, they agree, again, not to take any of that information. And again, if they do, you automatically have protected yourself. You have put yourself in the position of having a breach of contract case rather than a very ambiguous, intellectual property case that you haven't even, registered your copyright for. But you would still like to protect. Breach of contract wins all day, every day in any court of law. So by having that terms and conditions in place for your online course, you can protect and you can lay claim. You can very visibly lay claim to the copyright ownership of the work. But in that online terms and conditions, you can protect your work and explicitly say that they are not allowed to copy anything that you put forth in the online course. So again, that seems very simple, and having the password protected online course seems like a really simple answer. But honestly, I think a lot of the times the most simple answers are the most brilliant ones, or the ones that everyone looks past, that are sitting right in front of you the whole time. This is something that I've had clients or potential clients approach me and say somebody has copied their online course, and so I say, okay, show me your online terms and conditions, or your online course terms and conditions, and they say, what are you talking about? I don't have one of those. And honestly, like, they might still have a case, but they probably don't have the money to litigate it, because the more arbitrary or the more ambiguous your case is in the court of law, the more your lawyer fees are going to go way up, and on both sides. And you're just not many people are going to have the money, or not many people should spend the money to litigate those sorts of issues in court. Okay, so I've covered the three main ways I think you can protect yourself from getting copied before it even happens. And those are registering your trademark, registering your copyright, and having the online terms and conditions in place, either for just your general website or your online course, or your online sales would fall under that as well. That's another terms and condition of online sales. That's something that people have to check the box for anytime they place that online purchase. And so anytime you're nervous about sending your digital product out into the world, that's a seatbelt that protects you in any of those circumstances. I've also touched briefly on what happens once you found out that you've been copied, and that was with the cease and desist letters. The second option is going to be court, of course. That's always an option. Again, my background is entirely in litigation. That's what I'm entirely trained to know. And so I have a litigious mindset. I don't mind talking about going to court. That's something that is just very ingrained in me. But at the same time, we're business owners, and that's not something that I think all of us, or many of us, either can or should be trying to afford in our businesses. So the third thing that you can do, especially if you get copied online on any sort of like Instagram, any sort of social media platform, is file a DMCA takedown notice. This is a procedure that is put in place on platforms such as Instagram, Pinterest, Facebook. Those are the three main platforms I'm on, and so those are the terms and conditions I've read most closely. But this is a notice. You'll see more of this in a blog post I'm going to post later this week. But this is an avenue that you have in place to where if you see something copied, one of your works of art, even an Instagram post, something like that, copied online on a platform such as Etsy, Instagram, anything that I've mentioned, you have the option of filing what's called a DMCA takedown notice. This is something that you will file through that online third-party platform that you're using, and they will review the situation, and they will actually entirely take down the post or the listing or whatever it is that you are claiming infringes upon your work, of course assuming that they see the validity of your claim. I'm not going to get into it today, but that raises a whole separate host of legal issues. Platforms such as Etsy don't have a track record of actually having any sort of procedures in place to check the validity of the claims filed with DMCA takedown notices. But other platforms such as Instagram, Facebook, they'll actually take the time to review your case. At the end of the day, they do not want to be known as a hotbed for copyright infringement. And so they are very liberal when it comes to complying with these DMCA takedown notices. And it sounds like a very intense notice. All this is you filling out a form through that platform. You can find it on any of their terms and conditions. They'll have a link that's very easy to access to fill out this form. And what you're going to need to do is identify, again, the infringing work, identify what you're claiming is infringing upon your work, identify your work that you're claiming it has been infringed upon. And again, this is where your case that you've been building, all those screenshots that I've told you to collect, that's where this comes into play. Submit all of that evidence. And you're going to need to make a statement in, good faith. And I don't say good faith meaning it's a lie. I mean, you just have to stipulate according to your word that you're making a good faith effort to ensure that this is actually an instance of copying and that you believe, all the facts contained within your claim are true to the best of your knowledge. And you're going to have to make an electronic signature of that claim as well. And that's all a DMCA takedown notice is going to take. And from that point, the different platforms are going to have different rules about how they're going to follow through. But typically, you'll submit that notice, you'll wait a little while, and then you'll get notice from that platform saying, hey, we received your notice, we reviewed your case, we've taken down the infringing work. And that will usually, alleviate the issue at hand. So this is why I've been so hesitant to talk about copying, because I can go through all of these facts, I can talk about all of the factors and the ways to protect yourself and the ways to respond after the copying has occurred. But as an attorney, it is highly annoying to me to talk about this issue, because I feel like while I can help you prepare, and while I can help you after it's happened, I can't give you any surefire way of protecting yourself from having it happen in the first place. And that's really annoying to me, because I feel like that's my job. I feel like it's my job to protect my clients in every possible way. And of course, I do that to the best of my abilities. But the truth of the matter is, in the day of age that we are living in, copying can happen to anybody, and it happens all the time. So my last piece of advice for you is, if you believe this has happened, be a cold-hearted business person. Subtract all emotion from the situation. Even if that means that you have to get a third-party opinion, ask a friend who's going to be really honest with you. If it happens with me, I'd ask my husband, because he'd be really blunt about it, and he would say, you're overreacting, you're being emotional, or he would say, yeah, this is pretty glaringly obvious. Get that third-party opinion if you need it, but take the emotion out of it, and don't just sit around and kind of hem and haw and wonder how you should handle the situation. Once you subtract the emotion, you'll be able to discern whether or not it's something that you need to act upon, or if you just need to kind of determine your losses and move on, because at the end of the day, it's not always worth your sanity and your peace of mind and your time and expense to hold that copier accountable. And on the flip side, take ownership yourself. Don't assume everyone else is copying and that you are just completely impervious to it yourself. If you need to, don't follow your competitors. I really don't think there's many situations where you should be following your competitors, but have some integrity with it and draw those lines in the sand for yourself. And if that means that you want to kind of put your blinders on, I come from a background of horses, and some horses, you have to put blinders on them so that they don't get distracted and they stay entirely focused on what's ahead. It's what you see on racehorses. But again, that's me going on a nerdy tangent. But put your blinders on and just do the work. And just ignore what the people around you are doing, and really hold on and make an active campaign to hold on to that integrity in your own work. And sometimes that integrity translates into kind of letting some minor instances of copying slide off your back. So that's all I have today on copying. I hope this is helpful to you. And again, as always, if you ever have any questions for me, you can email me at hello@pagehulse.com. And I look forward to hearing from you. Thank you.